While I find it really helpful to introduce and familiarize parents with the process of special education law, I often realize that the actual law gets lost along the way. I'm Jennifer Ratcliff, and I have been practicing in this area since 2011. I like all my clients to be comfortable with the ins and outs of the steps that we will be going through when filing a case against their school district, but I also like them to understand what we would need to prove should their case ever go to a hearing. No parent should be learning this in the hearing itself. There are 3 parts or prongs to every special education case. The school district is required to provide your child with a free and appropriate public education, otherwise known as a FAPE or FAPE. Because of this, they have the burden to prove they have done so. We, as the parents, do not have to prove that the district did not provide an appropriate education. It is on the district to prove that they did. However, we have to poke holes in their case. It is often this part of any hearing that is the most heavily litigated, and most special education cases, at least in New York, usually hinge on this part of the case. In New York, because the school district has this burden, they are required to present their case first. The parents go afterwards. The second prong of the case requires parents to prove that the program for which they are seeking funding is appropriate for their child. Though we have to prove that the child is making or would make progress in this program, the bar that the parent has to meet to prove the appropriateness of their program is not as high as the bar the school district must meet. This is because the school district has a statutory obligation to provide all children in the United States with a free education. If they fail to do so, courts understand that parents have less means at their disposal by which to find programs. However, do not be fooled. The bar that the district has to meet is not terribly high either. That is why the first prong of every special education case is so carefully handled by every high-quality parent's attorney. It is critical. The third and last prong of every special education case is known as equities. This has to do with the parents' actions throughout the IEP and school placement process. Parents must be cooperative and must not hinder in any way the school district's ability to provide their child with a program and placement. If they do, the hearing officer can decrease or completely deny their funding award. Parents must provide the district with notice along the way of any of their concerns, as well as provide them with copies of any evaluations and provide them with proper 10 business days notice before placing their child in a private program, which is something we've covered in another one of our videos on this channel. Equities is also hugely important and not to be discounted. There are many people that have seen their tuition awards been denied or significantly reduced because they did not cooperate with the school district. That is why my best advice is to follow the instructions of your attorney to the letter and to make sure you ask questions about anything you aren't sure of. There are things that you can do months in advance that could have a huge impact on the equities of your case down the road. It's terrible to have a very strong case that is done in because the equities are not in your favor. So that's a very brief but hopefully relatively concise overview of what we are trying to prove in every special ed law case. One important thing that I need to leave you with is that if the hearing officer finds that the department proved its case that they have provided an appropriate program for your child, it doesn't matter how wonderful or appropriate our program is. Their analysis of the case will end there. So that's why it's really important to always be thinking about these issues way in advance in terms of what you were offered by the district and trying to support why that is inappropriate for your child before you get into a hearing situation. It is not enough that you, as the parent, just says it is not appropriate for your child. We need clinical support to back up that fact. And we have again discussed that on this channel, so you can now start to see how all these pieces are kind of fitting in together. I'll also leave you with the caveat that this is an area of the law that has been litigated in hundreds of thousands of cases, so my 5-minute overview is by no means comprehensive. If you want more information about this, check out the resources section on our website, check out our videos, or if you're particularly adventurous, you can email me and I can give you some of the names of some cases you can read for yourself. As always, feel free to reach out to me at jennifer@ratcliffelaw.org or at 646-741-3030. We hope to hear from you soon.